Good morning and welcome back to Baptist for Liberty. Today is Friday, June 13th. So we've made it through one more week. Woohoo! Alright. Yesterday we had one of our first guests on the show. Yeah, I suppose he would be our first guest. And that was really nice, and we had a lot of different topics pop up in our conversation on the drug war. And I think it's fascinating how you can take a topic like the drug war and it's like a spider web. It just goes off into so many different directions. It's all woven together. But one of the topics that we went into that I thought maybe I'd expand on today is the concept of jury nullification. I know a lot of people who listen to alternative news media and different talk radio shows may be familiar with that, but I don't think my average listener would be. So I thought that would be something good to read and talk about today. Okay, so jury nullification. Here's a really nice, I like just the way this is outlined with the history of it. It was written in 2001 by Doug Linder, and it's not too long, so it just covers the high points. So here we go. What is jury nullification? Jury nullification occurs when a jury returns a verdict of not guilty despite its belief that the defendant is guilty of the violation charged. The jury, in effect, nullifies a law that it believes is either immoral or wrongly applied to the defendant whose fate they are charged with deciding. When has jury nullification been practiced? The most famous nullification case is the 1735 trial of John Peter Zenger, charged with printing seditious libels of the governor of the colony of New York, William Cosby. Despite the fact that Zenger clearly printed the alleged libels, the only issue the court said the jury was free to decide, as the court deemed the truth or felicity of the statements to be irrelevant. The jury nonetheless returned a verdict of not guilty. Jury nullification appeared at other times in our history when the government has tried to enforce morally repugnant or unpopular laws. In the early 1800s, nullification was practiced in cases brought under the Alien and Sedition Act. In the mid-1800s, northern juries practiced nullification in prosecutions brought against individuals accused of harboring slaves in violation of the fugitive slave laws. And in the Prohibition era of the 1930s, many juries practiced nullification in prosecutions brought against individuals accused of violating alcohol control laws. More recent examples of nullification might include acquittals of mercy killers, including Dr. Jack Kevorkian, and minor drug offenders. Now, of course, there'd be some of these nullifications that you might agree with and some of these that you would not agree with. So, of course, there's a double-edged sword with jury nullification. I mean, with things such as the Sedition Acts or the fugitive slave laws, those are definitely immoral, and you would want those to be nullified, whereas in the case of especially the specific Dr. Jack Kevorkian for so-called mercy killings, no. Murder is murder. Okay, so moving on. Do juries have the right to nullify? Juries clearly have the power to nullify. Whether they also have the right to nullify is another question. Once a jury returns a verdict of not guilty, that verdict cannot be questioned by any court, and the double jeopardy clause of the Constitution prohibits a retrial on the same charge. If I understand it, it's the double jeopardy is only on charges of where the defendant's life is on the line. But I could be mistaken on that. Early in our history, judges often informed jurors of the nullification right. For example, our first Chief Justice, John Jay, told jurors, "You have a right to take upon yourselves to judge both the facts and law," in 1805. One of the charges against Justice Samuel Chase in his impeachment trial was that he wrongfully prevented an attorney from arguing to a jury that the law should not be followed. Judicial acceptance of nullification began to wane, however, in the late 1800s. In 1895, in United States v. Sparf, the U.S. Supreme Court voted 7-2 to uphold the conviction in a case in which the trial jury refused the defense attorney's request to let the jury know of their nullification power. Courts recently have been reluctant to encourage jury nullification, and in fact have taken several steps to prevent it. In most jurisdictions, judges instruct jurors that it is their duty to apply the law as it is given to them, whether they agree with the law or not. Only in a handful of states are jurors told that they have the power to judge both the facts and the law of the case. Most judges also will prohibit attorneys from using their closing arguments to directly appeal to jurors to nullify the law. Recently, several courts have indicated that judges also have the right, when it is brought to their attention by other jurors, to remove, prior to a verdict of course from juries, any juror who makes clear his or her intention to vote to nullify the law. And that's something that I've heard in the news, not very recently, but in the past couple of years. It's cropped up a few different times where members of the jury have been taken off by the judge because of suspicion that they might be pro-jury nullification. Alright, so our final paragraph here. If jurors have the power to nullify, shouldn't they be told so? That's a good question. As it stands now, jurors must learn of their power to nullify from extra-legal sources, such as televised legal dramas, novels, or articles about juries that they might have come across. Some juries will understand that they do have the power to nullify, while other juries may be misled by judges into thinking that they must apply the law exactly as it is given. Many commentators have suggested that it is unfair to have a defendant's fate dependent upon whether he is lucky enough to have a jury that knows it has the power to nullify. Judges have worried that informing juries of their power to nullify will lead to jury anarchy, the jurors following their own sympathies. They suggest that informing of the power to nullify will increase the number of hung juries. Some judges also have pointed out that jury nullification has had both positive and negative applications. The negative applications include some notorious cases in which all-white Southern juries in the 1950s and 1960s refused to convict white supremacists for killing blacks or civil rights workers despite overwhelming evidence of their guilt. Finally, some judges have argued that informing jurors of their power to nullify places too much weight on their shoulders. That is easier on jurors to simply decide facts, not the complex issues that may be presented in decisions about the morality or appropriateness of laws. On the other hand, jury nullification provides an important mechanism for feedback. Jurors sometimes use nullification to send messages to prosecutors about misplaced enforcement priorities or what they see as harassing or abusive prosecutions. Jury nullification prevents our criminal justice system from becoming too rigid. It provides some place in the joints for justice if jurors use their power wisely. Okay, and then to raise an interesting point here, it puts too much weight on their shoulders. That it is easier on jurors to simply decide facts, not the complex issues that may be presented in decisions about the morality or appropriateness of laws. When you consider that the form of government that we have, the average Joe is supposed to be involved in legislation and forming the laws, and the jury is supposed to be made out of your average Joe. It just makes me think of this continued perpetual dumbing down of our nation. It's, just there's another little strand in that tapestry there, the bigger picture. Okay, so that was that story. There's videos on YouTube, The Law You Won't Be Told. There's been cases of people who make pamphlets on jury nullification. They stand outside of courts to hand them out to people as they go into the court building. Then just to inform people of what jury nullification is, that if you're a juror, you have a right to nullify. And some judges get very angry about this, and some law officers around courts will arrest activists handing out jury nullification pamphlets. Let me see if I can find something else. Okay, so if you go to Wikipedia on jury nullification, they have a little more background info here. Judges rarely inform juries of their nullification power. The power of jury nullification derives from an inherent quality of mostly modern common law systems, a general unwillingness to inquire into jurors' motivations during or after deliberations. A jury's ability to nullify the law is further supported by two common law precedents: the prohibition on punishing jury members for their verdict, and the prohibition, in some countries, on retrying defendants after an acquittal. Jury nullification is the source of much debate. Some maintain that it is an important safeguard of last resort against wrongful imprisonment and government tyranny. Others view it as a violation of the right to a jury trial that undermines the law. Some view it as a violation of the oath sworn to by jurors. The United States, some view the requirements that jurors take an oath to be unlawful in itself, while still others view the oath's reference to deliverance to require nullification of unjust laws. Will well and truly try, and a true deliverance make between the United States and the defendants at the bar, and a true verdict render according to the evidence, so help me God. United States versus Green. And it gives some numbers. I guess that's case information. And that was circa 1977. Some fear that nullification could be used to promote violence against society. Some fear that nullification could be used to permit violence against socially unpopular factions. They point to the danger that a jury may choose to convict a defendant who has not broken the letter of the law. However, judges retain the right both to decide sentences and to disregard juries' guilty verdicts. Acting as a check against malicious juries, jury nullification may also occur in civil suits, in which the verdict is generally a finding of liability or lack of liability, rather than finding of guilty or not guilty. The main deontic issue involved in jury nullification is the tension between democratic self-government and integrity. The argument has been raised that prosecutors are not allowed to seek jury nullification, and therefore defendants should not be allowed to seek it either. Nevertheless, there is little doubt as to the ability of a jury to nullify the law. Today, there are several issues raised by jury nullification, such as whether 1. Juries can or should be instructed or informed of their power to nullify. 2. A judge may remove jurors for cause when they refuse to apply the law as instructed. 3. A judge may punish a juror for exercising the power of jury nullification. 4. All legal arguments, except perhaps on motions in limine to exclude evidence, should be made in the presence of the jury. In some cases in the United States, a stealth juror will attempt to get on a jury in order to nullify the law. Some lawyers use a shadow defense to get information entered into the record that would otherwise be inadmissible, hoping that evidence will trigger a jury nullification. Okay, and it brings up the common law precedent. The early history of juries supports the recognition of the de facto power nullification. By the 12th century, common law courts in England began using juries for more than administrative duties. Juries were composed primarily of laymen from the local community. They provided a somewhat efficient means of dispute resolution with the benefit of supplying legitimacy. And so on and so on. And this is from Wikipedia, jury nullification, and of course, check their references. They list at the bottom of the page for everything. Wikipedia is an okay site, but you have to, if you use Wikipedia, check their references. That's my recommendation. Alright, I'm sorry, I've been coughing today. Drank lemon water as advised by my mom to help keep that under check, but oh well. Anyway, I've been on some light reading lately, including books, New World Order, The Ancient Plan of Secret Societies. A while back, oh goodness, I guess it's been almost a year ago, one of the issues I was going to do an editorial called Books on the Shelf, and I was going to do an extensive book review of some books that I read when I was younger, that I'm currently reading, that, these books have been my family for a really long time, so I'm familiar with the concept of what's in the books, even though I haven't read them from cover to cover. And I never got around to it because, just bouncing around between so many other projects and commitments. So, this can't be that extended book review because I haven't finished reading all these books just yet. But some of the titles that I've been working on is the one I just read. The title of is by William T. Still. It was printed in 1990, though I think most of its contents focuses on the first chapter or so, focuses on the Nixon administration in the 70s, as well as details from the 80s when things actually went to court, or information actually came out in almost 10 years after the fact or more. During Senate confirmation hearings in 1987. So, one of the things I found interesting about that was he goes in details on how DC and things happen, and they put out what they call balloons just to test them. How people would respond to an idea, and this particular balloon that he mentions is in regard to a military coup in order to keep Nixon in office. And that struck me as very interesting, given during this last election season, people were talking about Obama trying to force his way into staying into office. But and the author of this, he became informed of it because his father was a retired lieutenant colonel, U.S. Air Force, who somebody had approached and just kind of asked him how him and his buddies would feel. It was basically using this lieutenant colonel as part of the testing to see how people would respond to this idea of a military coup. Military coup. P is silent. Anyway, the other books that I've been reading is A Planned Deception, The Staging of a New Age Messiah by Constance E. Cumby, the author of The Hidden Dangers of the Rainbow. And I'm about halfway through this book. I started a while ago, though. It's the content is good information. I'm a little frustrated, though, because she really did need an editor. I know I'm a terrible speller, and there's a lot of things I miss even in editing the newsletter. But this is a book put out, by a professional book publishing in Detroit, before the days of self-publishing really took off. So, I don't know, it just irritates me. Bad sentence structures, words in that looked like they're from like the original draft, and she changed her mind on what the sentence was supposed to read like. And I know as a writer I do that sometimes, but that's why you have to go back and edit and fix any of those extra words in there that was from an old sentence structure that needs to be taken out. And also just repeating herself over and over again in ways that's like, you said that the same statement at the beginning of this paragraph, and it's not like a sentence to highlight a point, it's just being redundant for the sake of being redundant, it seems. And constantly quoting her previous book, The Hidden Dangers of the Rainbow. As for what the book itself is about, it's good. It goes through the secret societies a little bit, not a lot, but mostly it focuses on the New Age movement and the New Age movement within Christianity and red flags that most laymen there don't notice. It goes over their head, but there it is. I don't agree with all of her conclusions, and quite frankly, I think she's a little too nice to certain quote-unquote Christian leaders. I think a lot of them do know what they're doing, and they are a part of the New Age movement on purpose. We got people like Joel Osteen today. Of course, this book was published, I don't know, in the 80s, I think, 85, so the year I was born. I haven't seen to see if she has any, updated versions of this. I'll have to check. If they have any updated versions, I'd like to read that just to compare and maybe have a smoother read through. And also, I don't want to be, too harsh on the editorial problems with the book, because she does mention, a lot of her research and stuff is actually people sent in a lot of things in response to her first book. And so now she's using all this more information that people sent to her, either to contradict her original book, but actually ends up proving some of her points, or fans of the book in support of her research and work, sending her more information. So just using all that new information to build up and the data she's already collected for the first one. Anyway, so it does reference the first book quite a bit, and it acts more like a second volume to the first book. Okay, so we are near the end for today's episode. So we'll get to our proverb of the day. So Proverbs 13. A wise son heareth his father's instruction, but a scorner heareth not rebuke. A man shall eat good by the fruit of his mouth, but the soul of the transgressors shall eat violence. He that keepeth his mouth keepeth his life, but he that openeth wide his lips shall have destruction. The soul of the sluggard desireth and hath nothing, but the soul of the diligent shall be made fat. A righteous man hateth lying, but a wicked man is loathsome and cometh to shame. Righteousness keepeth him that is upright in the way, but wickedness overthroweth the sinner. There is that maketh himself rich, yet hath nothing. There is that maketh himself poor, yet hath great riches. The ransom of a man's life are his riches, but the poor heareth not rebuke. The light of the righteous rejoiceth, but the lamp of the wicked shall be put out. Only by pride cometh contention, but with the well advised is wisdom. Wealth gotten by vanity shall be diminished, but he that gathereth by labor shall increase. Hope deferred maketh the heart sick, but when the desire cometh, it is a tree of life. Whoso despiseth the word shall be destroyed, but he that feareth the commandment shall be rewarded. The law of the wise is a fountain of life, to depart from the snares of death. Good understanding giveth favor, but the way of the transgressors is hard. Every prudent man dealeth with knowledge, but a fool layeth open his folly. A wicked messenger falleth into mischief, but a faithful ambassador is health. Poverty and shame shall be to him that refuseth instruction, but he that regardeth reproof shall be honored. The desire accomplished is sweet to the soul, but it is abomination to fools to depart from evil. He that walketh with wise men shall be wise, but a companion of fools shall be destroyed. Evil pursueth sinners, but to the righteous good shall be repaid. A good man leaveth an inheritance to his children's children, and the wealth of the sinner is laid up for the just. Much food is in the tillage of the poor, but there is that is destroyed for want of judgment. He that spareth his rod hateth his son, but he that loveth him chasteneth him betimes. The righteous eateth to the satisfying of the soul, but the belly of the wicked shall want.